Hello, my name is Vivian Lyon. I am an Oregon attorney, and I would like to tell you about some recent changes to Oregon's landlord-tenant laws when it comes to the topic of tenancy terminations. You may be wondering whether Oregon still has no-cause terminations, and you may be uncertain about what the new rules are. Let's separate fact from fiction when it comes to the changes created by the adoption of Senate Bill 608. I will start by explaining what Oregon's law was before this big change. Then I'll tell you about the new rules regarding terminating tenancies. Finally, I will tell you about what might happen if someone breaks the new laws. So let's get started. Before the spring of 2019, Oregon state law allowed landlords to terminate tenancies in two general ways. First, if a tenant was breaking the law or rental agreement, the landlord could issue a variety of termination notices identifying the reason. This is a termination for cause. Second, if a tenant was on a month-to-month rental agreement, the landlord could issue a termination notice that said nothing about why the landlord was ending the agreement. That would be a no-cause termination. In addition, a landlord could also refuse to renew an expiring fixed-term agreement without giving a reason. Now the rules are different. Oregon has largely done away with no-cause terminations. In their place, the legislature has created a new type of termination that can occur in 4 different circumstances that landlords might find themselves in. Nothing has changed with respect to a landlord's ability to terminate a tenancy when a tenant has broken a rule. The legislature also created a new 3 strikes termination that I will explain in a bit. Let's start with the rules for month-to-month tenants. Landlords can still use no-cause termination notices during the first year of occupancy by giving a month-to-month tenant at least 30 days notice. After the first year of occupancy, landlords can no longer terminate tenancies without a stated cause. There is an exception to this rule if the landlord's primary residence is on the same property as the home the tenant rents, and if the property in question has no more than 2 dwelling units on it. In such a case, the landlord can still use a no-cause termination notice, but would need to provide a month-to-month tenant with at least 60 days notice. The landlord would need to provide a fixed-term tenant at least 30 days notice prior to the specified ending date of the fixed term, or the date designated in the notice of termination, whichever is later. Here are a couple of other notes on fixed-term tenancies. If the tenant has a fixed-term tenancy scheduled to end within the first year of occupancy, the landlord can still refuse to renew the tenancy as long as they give the tenant at least 30 days notice. Also, fixed-term tenancies that are scheduled to end after the first year of occupancy now automatically become month-to-month tenancies after the end date arrives, unless the landlord and tenant agree to a new fixed-term tenancy, or unless one side has issued the other a valid termination notice. Here is one of the most important changes. Landlords have a new tool to replace the missing no-cause terminations. The new law calls it a termination for a qualifying landlord reason. There are 4 qualifying landlord reasons. The first reason is if the landlord intends, within a reasonable time, to demolish the rental unit or convert it to a non-residential use. The second reason is if the landlord plans to renovate or repair the rental home within a reasonable time, and the home either currently is unsafe or unfit to occupy, or the home will be unsafe or unfit to occupy during the repairs or renovation. The third reason is if the landlord is selling just the individual dwelling unit to a buyer who intends to live in their home as their primary residence. Under this circumstance, a landlord would need to provide the tenant with a special notice and evidence of the purchase offer within at least 120 days of accepting the offer. The fourth reason is if the landlord intends for themselves or a member of their immediate family to make the rental home their primary residence and the landlord doesn't own a comparable unit in the same building that is available. Immediate family is generally limited to spouses, domestic partners, blood or adopted relatives, an unmarried parent of a joint child, and children, grandchildren, foster children, wards, and guardians. If a landlord wants to terminate a tenancy for a qualifying landlord reason, the landlord must issue the tenant a termination notice at least 90 days in advance. The termination notice must specify the landlord's reason for the termination and must include supporting facts. A landlord issuing this type of notice must pay their tenant an amount equal to 1 month's rent at the time they issue the notice. However, there is one exception to this 1 month of rent rule. If the landlord owns only 4 or fewer residential dwelling units, that landlord would not be required to pay the 1 month of rent. Remember how I mentioned a new 3 strikes rule? This new rule only applies to fixed-term tenancies. The rule basically says that if a fixed-term tenant violates the rental agreement 3 or more times during a 12-month period, and the landlord issues a special warning notice at the time of each violation, the landlord can end the tenancy at the time of the fixed term instead of having it automatically convert to a month-to-month tenancy. In order to exercise this right, the landlord must have issued the warnings I just talked about, and then must also issue a termination notice of at least 90 days prior to the termination deadline, or 90 days prior to the specified ending date of a fixed-term lease, whichever is later. So what happens if these new rules are not followed? If a landlord terminates a tenancy in violation of the new rules on landlord-based cause terminations, 3 strikes terminations, or automatically converting leases, the tenant can pursue a claim against the landlord for an amount equal to 3 months of rent, plus whatever other actual damages the tenant has suffered as a result of the illegal termination. The tenant would also have a defense in any eviction case based on an illegal termination notice. Finally, there is a 1-year time limit for a tenant to file a lawsuit against the landlord under these circumstances. However, that 1-year period of time does not start until the tenant knows or reasonably should know that the landlord terminated the tenancy in violation of the new laws. These complicated new laws have left many people confused, so if you think the new law might apply to you, you should consider talking to an Oregon attorney for advice about your specific situation. I hope this presentation has helped you better understand Oregon's new tenancy termination laws. For information on other legal topics, please visit the Oregon State Bar's website.